Hey y'all, it's Kim. So this is from the Department of Justice Office of Professional Responsibility Executive Summary of Report. This is investigation into the U.S. Attorney's Office for the Southern District of Florida's resolution of its 2006 to 2008 federal criminal investigation of Jeffrey Epstein and its interactions with victims during the investigation. This was in November of 2020. Says executive summary, the Department of Justice or the Department Office of Professional Responsibility, or OPR, investigated allegations that in 2007 to 2008, prosecutors in the U.S. Attorney's Office for the Southern District of Florida, the USAO, improperly resolved a federal investigation into the criminal conduct of Jeffrey Epstein by negotiating and executing a federal non-prosecution agreement, or an NPA. The NPA was intended to end a federal investigation into allegations that Epstein engaged in illegal sexual activity with girls. OPR also investigated whether USAO prosecutors committed professional misconduct by failing to consult with victims of Epstein's crimes before the NPA was signed, or by misleading victims regarding the status of the federal investigation after signing. Let me open this up a little more, maybe. Okay, so got that. So overall, her overview of factual background. The Palm Beach, Florida Police Department, of the PBPD, began investigating Jeffrey Epstein in 2005 after the parents of a 14-year-old girl complained that Epstein had paid her for a massage. Epstein was a multimillionaire financier with residences in Palm Beach, New York City, and other United States and foreign locations. The investigation led to the discovery that Epstein used personal assistants to recruit girls to provide massages to him, and in many instances, those massages led to sexual activity. After the PBPD brought the case to the state attorney's office, a Palm Beach County grand jury indicted Epstein on July 19, 2006, for felony solicitation of prostitution in violation of Florida statute subsection 796.07. However, because the PBPD chief and the lead detective were dissatisfied with the state attorney's handling of the case and believed that the state grand jury's charge did not address the totality of Epstein's conduct, they referred the matter to the Federal Bureau of Investigation in West Palm Beach for a possible federal investigation. The FBI brought the matter to an assistant U.S. attorney, or AUSA, who opened a file with their supervisor's approval and with the knowledge of then U.S. Attorney R. Alexander Acosta. She worked with two FBI case agents to develop a federal case against Epstein, and in the course of the investigation, they discovered additional victims. In May of 2007, the AUSA submitted to her supervisors a draft 60-count indictment outlining charges against Epstein. She also provided a lengthy memorandum summarizing the evidence she had assembled in support of the charges and addressing the legal issues related to the proposed charges. For several weeks following submission of the prosecution memorandum and proposed indictment, the AUSA's supervisors reviewed the case to determine how to proceed. At a July 31st, 2007 meeting with Epstein's attorneys, the USAO offered to end its investigation if Epstein pled guilty to state charges, agreed to serve a minimum of 2 years incarceration, registered as a sex offender, and agreed to a mechanism through which victims could obtain monetary damages. The USAO subsequently engaged in additional meetings and communications with Epstein's team of attorneys, ultimately negotiating the terms of a state-based resolution of the federal investigation, which culminated in the signing of the NPA on September 24, 2007. The NPA required Epstein to plead guilty to state court to the then pending state indictment against him and to an additional criminal information charging him with the state offense that would require him to register as a sexual offender. Specifically, procurement of minors to engage in prostitution in violation of Florida statute subsection 796.03. The MPA required Epstein to make a binding recommendation that the state court sentence him to serve 18 months in the county jail, followed by 12 months of community control, home detention, or house arrest. The MPA also included provisions designed to facilitate the victim's recovery of monetary damages from Epstein. In exchange, the USAO agreed to end its investigation of Epstein and to forego federal prosecution in the Southern District of Florida of him, 4 named co-conspirators, and any potential co-conspirators. Victims were not informed of or consulted about a potential state resolution or the MPA prior to its signing. The signing of the MPA did not immediately lead to Epstein's guilty plea and incarceration, however. For the next 9 months, Epstein deployed his extensive team of prominent attorneys to try to change the terms that his team had negotiated and he had approved, while simultaneously seeking to invalidate the entire MPA by persuading senior department officials that there was no federal interest at issue and the matter should be left to the discretion of state law enforcement officials. Through repeated communications with the USAO and senior department officials, defense counsel fought the government's interpretation of the MPA's terms. They also sought and obtained review by the department's criminal division and then the office of the Deputy Attorney General, primarily on the issue of federal jurisdiction over what the defense insisted was a quintessentially state matter. After reviewing submissions by the defense and the USAO, on June 23, 2008, the Office of the Deputy Attorney General informed defense counsel that the Deputy Attorney General would not intervene in the matter. Only then did Epstein agree to fulfill his obligation under the MPA, and on June 30th, 2008, he appeared in state court and pled guilty to the pending state indictment charging felony solicitation of prostitution and pursuant to the MPA to a criminal information charging him with procurement of minors to engage in prostitution. Upon the joint request of the defendant and the state prosecutor and consistent with the MPA, the court immediately sentenced Epstein to consecutive terms of 12 months incarceration on the solicitation charges and 6 months incarceration on the procurement charge, followed by 12 months of community control. Epstein began serving the sentence that day in a minimum security Palm Beach County facility. A copy of the MPA was filed under seal with the state court. On July 7, 2008, a victim identified as Jane Doe filed in federal court in the Southern District of Florida an emergency petition alleging that the government violated the Crime Victims' Rights Act, 18 U.S.C. subsection 3771, when it resolved the federal investigation of Epstein without consulting with victims and seeking enforcement of her CVRA rights. In responding to the petition, the government, represented by the USAO, revealed the existence of the NPA, but did not produce it to the petitioners until the court directed it to be turned over, subject to a protective order. The NPA itself remained under seal in the federal district court after the initial filings and hearings. The CVRA case was dormant for almost 2 years while the petitioners pursued civil cases against Epstein. Soon after he was incarcerated, Epstein filed for the Palm Beach County Sheriff's Work Release Program, and the sheriff approved his application. In October 2008, Epstein began spending 12 hours a day purportedly working at the Florida Science Foundation, an entity Epstein had recently incorporated that was co-located at the West Palm Beach office of one of Epstein's attorneys. Although the MPA specified a term of incarceration of 18 months, Epstein received gain time, that is, time off for good behavior, and he actually served less than 13 months of incarceration. On July 22nd, 2009, Epstein was released from custody to a one-year term of home detention as a condition of community control, and he registered as a sexual offender with the Florida Department of Law Enforcement. After victims and news media filed suit in federal or Florida courts for release of the copy of the MPA that had been filed under seal in the state court file, a state judge in September 2009 ordered it to be made public. By mid-2010, Epstein reportedly settled multiple civil lawsuits brought against him by victims seeking monetary damages, including the two petitioners in the CVRA litigation. During the CVRA litigation, the petitioners sought discovery from the USAO, which made substantial document productions, filed lengthy privilege logs in support of its withholding of documents, and submitted declarations from the AUSA and the FBI case agents who conducted the federal investigation. The USAO opposed efforts to unseal various records, as did Epstein, who was permitted to intervene in the litigation with respect to certain issues. Nevertheless, the court ultimately ordered that substantial records relating to the USAO's resolution of the Epstein case be made public. During the course of the litigation, the court made numerous rulings interpreting the CVRA. After failed efforts to settle the case, the parties cross motions for summary judgment remained pending for more than a year. In 2017, President Donald Trump nominated Acosta to the Secretary of Labor. At his March 2017 confirmation hearing, Acosta was questioned only briefly about the Epstein case. On April 17, 2017, the Senate confirmed Acosta's appointment as Labor Secretary. In the decade following his release from incarceration, Epstein reportedly continued to settle multiple civil suits brought by many, but not all, of his victims. Epstein was otherwise able to resume his lavish lifestyle, largely avoiding the interest of the press. On November 28, 2018, however, the Miami Herald published an extensive investigative report that state and federal criminal investigations initiated more than 12 years earlier into allegations that Epstein had coerced girls into engaging in sexual activity with him at his Palm Beach estate. The Miami Herald reported that in 2007, Acosta entered into an extraordinary deal with Epstein in the form of the MPA, which permitted Epstein to avoid federal prosecutions and potentially lengthy prison sentences by pleading guilty in state court to 2 prostitution charges. According to the Miami Herald, the government also immunized from prosecution Epstein's co-conspirators and concealed from Epstein's victims the terms of the MPA. Through its reporting, which included interviews of 8 victims and information from publicly available documents, the newspaper painted a portrait of federal and state prosecutors who had ignored serious criminal conduct by a wealthy man with powerful and politically connected friends by granting him a deal of a lifetime that allowed him both to escape significant punishment for his past conduct and to continue his abuse of minors. The Miami Herald report led to public outrage and media scrutiny of the government's actions. On February 21st, 2019, the district court granted the CVRA case petitioner's motion for partial summary judgment, ruling that the government violated the CVRA in failing to advise the victims about its intention to enter into the NPA. The court also found that letters the government sent to victims after the NPA was signed described the investigation as ongoing, misled the victims to believe that federal prosecutions was still a possibility. The court also highlighted the inequity of the USAO's failure to communicate with the victims while at the same time engaging in lengthy negotiations with Epstein's counsel and assuring the defense that the NPA would not be made public or filed with the court. The court ordered the parties to submit additional briefs regarding the appropriate remedies. After the court's order, the department recused the USAO from the CVRA litigation and assigned the U.S. Attorney's Office for the Northern District of Georgia to handle the case for the government. Among the remedies sought by the petitioners and opposed by the government was rescission of the NPA and federal prosecution of Epstein. On July 2nd, 2019, the U.S. Attorney's Office for the Southern District of New York obtained a federal grand jury indictment charging Epstein with one count of sex trafficking of minors and one count of conspiracy to commit sex trafficking of minors. The indictment alleged that from 2002 until 2005, Epstein created a vast network of underage victims in both New York and Florida, whom he sexually abused and exploited. Epstein was arrested on the charges on July 6, 2019. In arguing for Epstein's pretrial detention, prosecutors asserted that agents searching Epstein's Manhattan residence found thousands of photos of nude and half-nude females, including at least one believed to be a minor. The court ordered Epstein detained pending trial, and he was remanded to the custody of the Bureau of Prisons and held at the Metropolitan Correctional Center in Manhattan. I'm going to stop this here, and then I'll continue on with the rest of this in just a little bit. But anyway, talk to y'all later. Bye.